right, welcome back to the House Judiciary Committee this Friday morning, May 15th. We're looking at S-193. The version that I'm hoping to vote on is 7.1, but version 6.2 has highlights that we can see some of the changes a little easier. And do you want to start with just the legislative intent and then jump ahead to the other sections? Because I know that kind of came from.
Yep, I can do that.
Work that you were doing. So.
Sure, let me pull it up. Okay, so I'm working with the highlighted version. I should say good morning, Katie McGlynn, Office of Legislative Counsel. Nice to see everybody. So the highlighting scheme, you can see that there are two colors. The yellow highlighting is sort of older changes that were made, and the blue highlighting is more recent changes that were made within the past day or two by House Corrections and Institutions. There's some blue language that came from Human Services. So that is what you're seeing there. So now, if you remember last time I was here, we sort of talked about how the only sentence in the original legislative intent that you looked at when the two committees met jointly, well, there are members of your committee there. I don't know if you were all there. Just had the sentence about DOC not operating the forensic facility. And it didn't say, the legislative intent said what the forensic facility didn't do, but it didn't say what it does do. So that first sentence was added to sort of summarize what it is the intent of the General Assembly for the forensic facility do. So to accomplish. So it is the intent of the General Assembly that the Secretary of Human Services shall establish and operate a locked, secure forensic facility for the competency, evaluation, stabilization, treatment, and care of persons who have been found not competent to stand trial or not guilty by reason of insanity for serious criminal offenses. And then the sentence that should be familiar at this point, DOC shall not operate or staff the forensic facility with the exception that employees of DOC may provide security services for the facility at the admitting area of and around the outside perimeter of the forensic facility if it is co-located on the grounds of a correctional facility. So that blue language was added yesterday at the admitting area of a forensic facility. So from there, I will skip ahead. I think I'm going to page 20.
Yeah, go ahead.
Just a quick question back on the intent language.
Sure.
The DOC operating the facility, is that just that they can't be, I guess I just want to kind of understand, is that they can't operate, they aren't the sole operator, or they can't have any operational function? I'm just kind of curious, like what?
I think your question might be answered when we look further into the bill. There's more specific language around what DOC can and cannot do. And remember, the legislative intent is aspirational and not binding. So I think the language later on might be more helpful.
Thank you.
Okay. Okay, so next we have a definition of forensic facility. The forensic facility means a locked, secure facility that's licensed as a TCR. And remember, a TCR is a licensing designation. Dale does the licensing, but it doesn't necessarily mean that the people in the forensic facility have to be in Dale's care and custody. A TCR, the rule isn't perfectly, it's not a perfect fit right now for a forensic facility. So later on in the feasibility report, you see language asking what modifications are necessary to the TCR rule to enable a forensic facility to be licensed as a TCR. So a forensic facility means a TCR where the Agency of Human Services provides for the secure competency restoration, evaluation, treatment, and care of persons with a qualifying condition who are involved in the legal system and who do not require a hospitalization level of care, and a person is transferred pursuant to 4815 and 4819A, subsections A. So as this committee probably knows best. Those are the two provisions that you've really been working on. I'm not competent to stand trial and not guilty by reason of insanity. In this section 5, there is a subsection B that House Corrections and Institutions has been spending some time on. And this is language to give more specificity around what the forensic facility would look like, what clinical services might be offered there, et cetera. So let's go through this. First, it says that the Secretary of AHS is establishing the secure forensic facility for the same reasons we've outlined a few times: competency restoration, evaluation, stabilization, treatment, care. The facility, the clinical services, forensic services, competency restoration are overseen by an AHS medical director. And here's a little more information about DOC. DOC shall not play a role in the forensic facility's operation, the provision of services, or internal security, except to provide security services for the facility at the admitting area and around the outside perimeter if it's co-located on the grounds of a correctional facility. So there wouldn't be, as this is drafted, there wouldn't be DOC within the facility unless it's the admitting area, and DOC wouldn't be providing clinical services to residents. And DOC is, their responsibility is sort of limited to when they're co-located on the grounds of a correctional facility. So if the feasibility plan report comes back and the proposal is to have the forensic facility separate and apart from a correctional facility, then DOC wouldn't have a role as this is drafted.
So I guess my question, that's very helpful. I'm glad that we waited to kind of understand what the scale and scope is. How does that differ from DOC's role from the original versions that we saw?
Meaning what came over from the Senate?
Yeah, exactly.
In the Senate, the forensic facility was operated by DOC. So they were responsible for sort of the physical premise. They were responsible for, if not providing the clinical services, then contracting to provide for the clinical services.
Okay. Because I think, I guess what I kind of come back to is, I guess I never really, my own personal opinion is I never really expected DOC to be administering the services that we're talking about for this population of individuals. Contracting, it seems to make sense because WellPath was those that were capable of doing that. But I guess I just wanted to understand how different DOC's role has been, I think, constricted in this new version. So it seems like it really is just external security. But I guess aside from, I just want to maybe have you repeat what you just said. Aside from providing clinical services, DOC's role was what? Just providing security inside the facility? The forensic facility would have been inside a correctional facility as it came over from. So this is now contemplating a separate and apart location. Okay.
Yeah.
Okay. Thank you.
Okay. Yeah, but this, if I'm reading this right, on line 11, corrections shall not play a role in the forensic facility's operation or provision of services, internal security. If there's a problem in there and that there's an uprising or people are out of control, who's going to get control of that situation?
I don't know what type of testimony you heard, but I imagine it would be similar to how, let's say, the psychiatric hospital is staffed, where there's not DOC correctional individuals in the hospital setting, but there is a staff security either by the providers or by contract with DMH and security personnel.
Okay, thank you.
Okay, along those same lines, do you know what kind of training the staff goes through as far as doing things for security or getting people under control?
I don't have that answer for you, I'm sorry. Okay, so now we've looked at the lead-in language, and there is a list that the forensic facility shall be designed and operated in a manner that supports therapeutic, recovery-oriented, and trauma-informed programming at a TCR while maintaining appropriate levels of safety and security. Top of page 22, not refusing a person, it is ordered to admit and shall not require any clinical or diagnostic prerequisites for admission. Provide for the safe competency restoration, evaluation, treatment, stabilization, and care of persons, including the ability to separate the population by sex or gender and to otherwise address clinical safety or operational considerations as appropriate, including the possible operation of multiple facilities. In subdivision 4, following the direction of the medical director, the AHS medical director, who is to oversee the forensic, clinical, and competency restoration services provided to residents. In subdivision 5, implement staff qualifications, licensure, training, and supervision requirements that are sufficient to ensure that persons transferred to the forensic facility have access to clinically appropriate care, treatment, and services and supports consistent with their individual needs and applicable professional standards. In subdivision 6, ensure that a registered licensed nurse or a licensed physician is available 24/7 to provide care. That doesn't necessarily mean they're physically present to provide that care. They could be telemedicine. Subdivision 7, ensuring that the person receives clinically appropriate assessment and treatment planning and competency restoration plans as appropriate, including a development of an initial person-specific treatment within 72 hours of the transfer, and that plan has to be reviewed periodically. In subdivision 8, ensuring clinical services and programming include psychiatric care, management of medications, education about court procedures, rehabilitation, and trauma-informed care is appropriate. 9 is continuing to provide evaluation, treatment, stabilization, and care of a resident who has regained competency while the resident awaits and participates in the resident's trial. 10 is providing residents with interpreters as appropriate. 11, implementing grievance and appeal procedures. And then lastly, implementing a process for reporting instances of death or serious bodily injury to residents of the facility to the AHS medical director. Okay, I'm gonna speed along. Next, we come to section 4A. You'll see it's all struck through on the highlighted version. You won't see it at all if you're looking at the non-highlighted version. That was a proposal that came over from the Senate to establish annual reporting requirements about the forensic facility. The decision down the hall was to remove this language and also rulemaking language, thinking that that was sort of putting the cart before the horse and that it would be more helpful to sort of receive the feasibility plan back, finalize a plan for what the forensic facility would look like moving forward, and then putting annual reporting requirements in place and putting the rulemaking requirements in place. So you'll see 4A and 5 are struck through. Section 6 is language that was added by House Healthcare, and this requires, it's an existing section that requires reporting of adverse events at various locations where individuals in DMH's custody could be, like a psychiatric hospital, secure residential. So this just adds forensic facility to that list for the reporting requirement.
Just a quick question about that, Katie. I noticed that that's like very similar language added on page 23. In the blue highlight, number 12.
Yeah, so that was added, the blue language was added by Human Services. They wanted something similar for a population of individuals that would be in the custody of Dale, and that didn't really exist anywhere else. And then they were thinking maybe there are other folks beyond somebody with mental health and who would be in the custody of Dale, and you'd still want those reporting requirements coming to somebody. So that is meant to be a catch-all to collect information about all populations of who would potentially be in the forensic facility.
Gotcha. Okay, so it's important to have it in both places.
Yes.
Okay, thank you.
Section 7 is the feasibility plan. So as you well know at this point, there's a plan coming back in January. From from the Secretary of Human Services in consultation with BGS. It's a plan for the development and operation of a forensic facility, and it's coming back to 7 different committees. The plan assumes that operations, staffing, and programming at the forensic facility is to be provided by HSERT's departments, with the exception that DOC is not to play a role in its operation, the provision of services or internal security, other than the provision of those security services in the admitting area around the outside perimeter if co-located on the grounds of a correctional facility. So you've already seen that language once in subsection B. Now you're seeing it repeated again here with regard to the feasibility plan. And then we have a list of everything that's going to be in the feasibility plan. The proposed location of a forensic facility, which shall be independent from a correctional facility, and if on the same grounds as a correctional facility, shall be separated by sight and sound. Proposed design plans for a forensic facility that allows for the ability to separate residents by sex or gender and clinical need.
Yeah, go ahead.
How can it say on line 16, what am I missing? Or starts on 15, which shall be independent from a correctional facility,
Mhm.
but if on the same grounds as a correctional facility. So how can it be independent?
So the conversation about that next down the hall was to try to clarify that it wouldn't be embedded within an existing correctional facility building, but that it could be on the same grounds as long as it was separated by sight and sound.
Right?
Does separated by sight mean that you can't see it from the other facility?
That was the conversation that they had down the hall.
So does that mean that you can't see it?
That's how I would interpret it, that there's something to separate. I don't know what that would be, if it would be fencing or if the grounds are large enough that I'm not exactly sure what that would look like. I think that's why there's a plan.
Yeah.
But yes, yeah.
The way I took it is sight and sound as far as looking into the
That's how I
building.
framed
Oh, interesting.
Because it's going through my mind, if it was a wing,
That was how-
Springfield, as long as there's some construction done for noise and for sight between the 2 facilities, that would cover this.
Yeah, and just thinking about the juvenile
Right,
context,
exactly, yeah.
juveniles are, segregated based on sight and sound requirements, meaning, and they're just like in the facility.
They don't share a yard. Right.
Yeah, they're like in the same facility, just in
Right.
a cell. So I wonder, how it would be.
So,
interpreted.
with juveniles, it is what I'm describing?
It's even.
If we're close,
It's
Okay.
like that and even less restrictive, I think.
right?
I don't know.
Because going to a separate building, I mean, if all we can afford right now is the wing down in Springfield, that eliminates it if the building is out of sight and sound. And do we even, I mean, I know I don't know what Northwest looks like, but supposedly there's a building up there, but how far away is that from the original or from the facility itself? It isn't far enough away. I mean, if it's a half a mile away and you can see the roof.
That's not what, yeah. I was gonna say, again, with the juvenile ones, it's like you're not having people eating in the dining room together, that are up there at the same time so that you can see prisoners or hear the prisoners. And there probably is a definition of it in the JJDPA,
So,
which Eric would, so it's a very well used phrase.
Right.
And it isn't like put trees up and a 10-foot fence.
right, but it sounds like some of the conversation down there may have been separate buildings far away.
Barbara, what's the JJ?
It's the Federal Juvenile Justice and
Oh, okay.
Delinquency Prevention Act.
I was just curious, we had a situation recently in Rutland where Marble Valley wouldn't take a juvenile because there was no way, they would have to clear out an entire section of the jail just to take the juvenile, so it is pretty
So
serious.
I guess my fear is is, well, number one fear is another study, which feasibility study. Is that if there's no money to say, if Northwest is closer to this definition, the way that corrections takes it, but there's no money to do what needs to be done there in the cheaper version to get started, that's gonna be a fine facility as long as you got the people inside doing the treatment, is Springfield, because there is a wing down there that we don't do it because of the way that the definition is interpreted.
So,
And I think.
no, I don't want to hear that. Right.
It almost seems like the definition needs to be defined more, or at least investigated what the definition is, the way it's being used now. Because Springfield needs to be an option. And from what I've heard so far, it's going to be the least expensive option, potentially to get us started until maybe we can build a standalone or renovate, somewhere else that's going to be not as cost effective.
So let me make just two comments on this. That the feasibility plan, I think there's some flexibility in here. They're addressing these different issues. And if they come by and they say, there's no way we can have a separate building 3 miles away on DOC land, I mean, would be addressing it. So that's the one thing I would say. But we haven't gotten to, I think, probably the most important change that makes me comfortable with this, which is number 12, which we'll get to in a minute. And that was like in the interim, services can be in DOC a facility. But let's.
It just worries me. I know we're pressed for time, but it just worries me that as much say as corrections has with corrections buildings and this bill, that their interpretation sounds like they were discussing that building on DOC property 3 miles away. And not a broad definition.
Right. No, understood. But let's go let Katie go through the rest of this so we can have further discussion. We'll circle back to that.
Okay.
Yeah.
So it's on subdivision 3, number of beds within the forensic facility. 4, entity or entities responsible for operating and providing services. 5.
Katie, what page you on now? I'm sorry.
Oh, I am on the top of page 28. Subdivision 5, timeline for constructing a standalone facility or fitting up an existing standalone facility to operate as a forensic facility. 6, estimated cost of constructing or fitting up and operating a facility. 7, I mentioned earlier, it's the modification of the TCR rules. 8 is clinical services available at a forensic facility, including on-site competency restoration services. 9 is proposed staffing levels, staff qualifications, and potential contracting needs necessary to establish a multidisciplinary clinical team at the facility that reflects best practices, including evidence-based, trauma-informed staff training and multiple potential staffing strategies. 10, physical and staff security plan within and around the perimeter of the forensic facility, including therapeutic design, clinical supervision that reflect best practices, which shall not involve DOC with the exception that employees of DOC may provide that security for the facility at the admitting area and around the perimeter if it's co-located on the grounds of a correctional facility. A resident discharge and community monitoring plan for each department with custody of individuals in the forensic facility, developed in consultation with the Department of Corrections, that prioritizes community safety and provides residential, clinical, and case management services. Number 12 is opportunities and cost estimates for persons who would be eligible for placement at the forensic facility to receive the following services while the development of a forensic facility in Vermont is pending. So first is placement at an out-of-state residence where clinically appropriate programming can be provided. Second is competency restoration program within a Vermont correctional facility provided by an entity that is not under contract with DOC. 13, a plan for expanding Act 248 populations to individuals with cognitive disability. 14, annual reporting metrics and demographics, outcomes, staffing. And then lastly, any other recommendations for the development of the facility. So that is it for my sections.
I would flag the sunset on page 1. Sunsetting that section 12 that we just talked about for like in the interim, the services can be within correctional facility. There's a sunset on that component, right? Did I miss that?
Technically,
Yeah.
Eric.
Yeah, that was a surprise to me.
We were having to figure out who staffed what yesterday, so even though these are Katie's sections, I got called into ask corrections institution, so I got it, so in Katie's defense. She didn't know about it, my fault for not giving her a heads up on it. So I think, Katie, that's not.
Legislative intent is on page 1, of course. Talks about Department of Corrections may provide security services. And then, other place I picked it up with page 21, around the lines of 11 to 14, right in there. It says basically the same thing, but it doesn't say may. And then, where did it go? On the bottom of page 28, it goes back to may. So with the language on page 21, would the intent trump that language as far as the may language goes?
I need to follow all your breadcrumbs. I'm sorry. Give me 1 minute.
You're gonna make me repeat that.
So I'm looking at the legislative intent language. So DOC shall not operate.
On line 15 is
Yeah.
where the may is.
The exception that employees of DOC may provide. Okay, and then the next one was page 21.
Yeah, page 21 in the blue, I think it's blue, I may be a little kind of white.
It's
It doesn't have a may in there.
shall line 11.
Yeah, shall not.
Not play a role. Exception.
And that's kind of the same language as the inside and in the internal security. But then, we jump to page 28, it goes back to a may provide security.
Where's the may on that one?
Which one? 28?
28.
Page 28, the bottom of page 28.
See, shall not again. Where are you, Tom?
Yeah, I can see it.
All over the place, obviously.
Yeah, but where were you just?
21 and 28 match. 20, legislative intent section 1, you're saying doesn't match.
I think legislative and, I mean, the way that I read it, and maybe I'm reading it wrong, but legislative intent and page 20, bottom of page 28 match with the may.
Mhm.
In page 21, there's no may as far as talking about security.
I don't think there's a problem in wanting them all to align. I think that makes sense. I'm sort of reading into them that it's saying the same thing in different ways, which is that, let's see, that in general, DOC is not providing any services but the exception is that they could be providing services. They may be providing services if there's a co-location at the forensic facility, in which case they could be providing security services at the admitting area or at the outside perimeter.
So you don't see a problem with it?
Well, it's always nice to be consistent. So to the extent it's not consistent, I think it's fine to make them align so there's no question.
I guess I don't see that they're inconsistent. It's slightly different language on 21 versus page 28. You shall not play a role, and then there's the exception that they can provide those security services. And then on page 28, shall not involve corrections, except, there's an exception, but the way the exception stated is that they may provide security services. So it's kind of the same outcome.
Yeah, that's the way I
Right, right.
understood.
Yeah.
What Katie was saying.
Yeah, okay.
So either way, it would be fine.
So,
Yeah, my head, you know. Okay.
so in my head, just to be clear, we're talking lines on page 28, we're talking lines 18 where it says shall not and 19 where it says you may. Is that where you guys are?
Say what's page?
Yeah, kind of, yeah.
28,
Yeah.
lines
The
18.
intent on page 1 says may provide
Yeah,
security. Page 28 says may provide security. And page 21 didn't say that, but not understanding, I guess, admittedly not understanding exactly how it's worded. In a sense, page 21 says the same thing. That,
I think they're all
Oh, it's-
saying the same thing, but they are all worded differently. I take your
Right.
point. And, you know,
okay.
if you'd like consistency, that is definitely
It-
possible and easy to do.
To be totally transparent, I don't like may. Would rather have a shall in there. But I just wanted to understand that if they were totally different, I guess, it doesn't seem like they are. So I don't have a problem with the consistency, I guess,
Mhm.
other than it's not as consistent direction I want.
Okay, so I think you have to run somewhere else. Okay, so we'll go to
Thank you,
Eric.
Katie.
Yeah, we'll go to Eric,
Thank you.
and we'll go to the first 4 sections, and we'll let Eric guide us on whether he wants us to look at 6.2 or 7.1.
Morning, everybody.
Good.
Eric Fitzpatrick with the Office of Legislative Counsel here to pick up from Katie's walkthrough of S-193 and now turning back to the sections that this committee has been spending the most time, which are the first few sections of the bill. I would suggest looking at the clean copy if that's possible. It kind of gets us closer. I can just point out, unless you prefer seeing the blue highlights, I can point out as you go through, there aren't that many, a couple of places that there were changes.
highlights?
Yeah. either way.
Yeah. Easier for me to find. things.
Yeah, definitely. So on, that would be, is that everyone looking at version 6.2?
Yep.
All right. So there is the, well, I'll mention that when I get to it. There's one sentence that's not in the 6.2 because it came in even later, but I'll redo that when we get to it because that is in 7.0. So on the other stuff, the other changes are highlighted in blue, however, and the first one's one of the most crucial parts of S-193, which is what, who are the population of people that are eligible for treatment at the forensic facility. And that is in subsection A on page 2. So this is your very first section about competency restorations. Remember, these are the folks who have been found not competent to stand trial. So we're not dealing with the not guilty by reason of insanity population at this point. It's just the not competent population. And you'll see in subsection A, the new language in subdivision B, which is lines 12 through 15. So the idea here is that, and I believe this is language that's reflects the conversations you've been having this week, in particular with folks at Dale. And this is to carve out, as has been an effort at synthesizing the concerns of the House Human Services Committee in particular about the population of people who are found not competent to stand trial because of intellectual disability. Under current law, those folks are sent to the custody of Dale currently. So their thought initially, this isn't the way it turned out here, but their initial thought was those folks should be completely carved out from the forensic facility because they're being treated with a placement at Dale. So the resolution after that back and forth discussion is what you see in B, which is that those folks aren't carved out completely. It's only if, and you'll see the language. So, you sort of parallel just to think of it, how it's working, look at the existing language, which hasn't changed in 3A. So for example, as has been the case from the beginning, there is a carve out. You don't go to the forensic facility if you're currently receiving treatment through an order of hospitalization, and that is DMH custody. So those folks have from the beginning not been the ones who are, because those are folks who are, because of a mental illness, are getting a hospitalization level of care. They have to be hospitalized. They could still be under DMH custody and come out under an order of non-hospitalization, for example, and then they would go to the forensic facility. But while they're in the hospital, which means I don't have medical expertise personally, but my understanding is they have a certain threshold level of medical need that requires them to be hospitalized. And that population, as has been the case from the beginning, doesn't go to the forensic facility. So subdivision B conceptually parallels that and says, all right, what about this other population of not the mental illness in a hospital population, but the intellectual disability Dale population? It says, so the way it's phrased, you see, is they are carved out too in the first clause, subject to an order of commitment to the Dale commissioner. So that means that's referring to Act 248, the intellectual disability dangerousness. Unless, see subdivision, so there's a qualification there, unless the person is detained in a correctional facility pending trial. So in other words, if the person's already in Dale custody, yes, they stay. They don't get moved from that situation to the forensic facility. But they're charged in the future with one of these qualifying offenses, offense punishable by life in prison, and held without bail or held in a correctional facility otherwise, then they do go to the forensic facility. So, and your practicing attorneys will have a better sense of this than I do, but generally speaking, I think it's generally true that for the majority of offenses, when you're charged with a life sentence, very serious criminal offense, and particularly the way the hold without bail statute is phrased, in the majority of situations, you're going to be held without bail. So, and that means that in the majority of situations, you could be, the intellectual disability person could be sent to the forensic facility because they're at least likely going to be held without bail.
So you can be held without bail in a correctional facility or forensic facility?
Well, you can be held in either one, yes.
Okay.
So yes, if you're being held without bail, then I think the idea is that if you're then, while you're being held without bail, you're found incompetent to stand trial or not guilty by reason of insanity, you don't walk, you go to the forensic facility. I think that's part of the purpose if you're looking at who gaps in the system that where someone might be in the
Then
community
at that point, you would go through all the competency
while you're there. Yeah, exactly.
6 months checkup.
Yep. Yep. That's the idea for sure. So that's where the proposal is, the proposal for how to address that population. And that comes out of the, as I say, the ongoing conversations that have been happening in this committee for the past week, if not longer. Then let's see if I'm not sure if this did turn up in the draft that you're looking at. Actually, it did not. So, so there are a few other changes that actually are not in this version, because as I mentioned before you got started, these are the result of conversations, the very last bit of testimony that you had yesterday afternoon from the Commissioner Dale and Dale's general counsel about some technical fixes that had to be made here. So they were made last night after that version 6.2 got voted on in House Corrections, which wasn't their
7.1?
Correct.
Where are we on 7.1?
I'll point them right out here.
I personally think we ought to be focusing on the last version. I think that's what we're going to be voting.
Yep. whatever works for you guys.
Well, I don't run this room, but I should. I should. I say we need to switch to 7.1. This is the version we're going to be voting on, and you guys were in a thing, and I don't think you heard, but we're jumping over to 7.1 to see where he's going.
So he was doing that. Yeah, that's,
Yeah, because I gave him the idea. Thank you.
yeah, okay. Oh, that's.
All right, so that being said, look at the next page, page 3.
7.1.
Exactly. Clean copy. You see it all just pages with white background, black type, no colors, right?
Don't rub it in. He's ready to.
So page 3, top of page 3, this is the concern that I think correctly General Counsel Dale mentioned to the committee yesterday afternoon, which is that the way, and this is the idea, it's just, as I say, it's really a technical clarification. Because remember, the idea throughout this bill in a number of different places is that when a person is at the forensic facility, as you were just mentioning, Representative Burdett, they get this reevaluation every 6 months or sometimes every 12 months. But in addition to that, they can also be reevaluated if the Agency of Human Services medical director says, in the meantime, hey, wait a second, looks like this person's actually has regained competency. So they want to have the reevaluation sooner than the 6-month period. They can do that because they're the one providing the services. If they notice that the person's competency is likely restored, they can let them know anytime. They don't have to wait for however many months are left until the 6-month period expires. So it's just how to phrase that correctly is all this is. And that's page 3. It happens a few times, lines 3 and 4. So the idea was just to make sure that it's not inadvertently interpreted by a court, for example, or whoever, by the agency who's applying it, to mean that it's one or the other. It's not one or the other, it's both. So it's 6 months, every 6 months, and subdivision B, line 4, at any time. That's the new wording, those first 1, 2, 3 words, or 4, I guess. Well, maybe, okay, that's a good 3. So at any time, upon the determination of the medical services director that they are likely competent. So technical, that's first change, or the only change on that page, actually. All right, so that brings us to exact same change you'll see page 5. And this is the situation where the state's attorney has successfully shown that the person is dangerous and is not going to be released. Remember, what that happens, then they don't have the 6-month review anymore. It becomes a 12-month review. So if it can't be restored and they're dangerous, they stay at the forensic facility, but they can get relooked at every 12 months. And so if you see, at least on my version, it may be line 17 or 18 or so of your version, that you'll see there's an every 12 months little Romanet I,
Yeah. 19.
followed by, not by the word or, but by the word and, correct?
Yeah.
And then in the next Romanet 2, you'll see the same words, at any time upon, right? So that's the same change again. So that's that piece.
That was a question.
Yeah.
Eric, I'm sorry. But there is more changes. If you go from 6.2 to 7.1, that 3A, it starts off if the court finds after the hearing, right? But then it's added in 7.1, notify the state's attorney. Unless I'm missing it, I don't see where that's on 6.2. There's a lot of language that, oh, wait a minute.
It's at the very end.
Notify- Got it. Damn it. I mean, darn it. Thank you.
Yeah.
Let me,
So, and actually, interestingly, that's going back to that language. Let's go back to the way it passed the Senate.
what I just brought up.
Yep. But it's the same. It's not changed from 6.2. But like the other changes we make is
Right,
you just get rid of the highlighting and the struck language and all that.
right. Thank you. Thank you.
You bet. So that brings us to, let's see. all right, so this is another place. Now, if you look at page 8, now we're in and it's subdivision, Romanet 2, lines 13 through 17. And when we're in this group of people, we're talking about, again, it's the Dale universe, right? It's the folks who,
Are you on page 6 now, line 14? Is that where you are?
are you on 7.1?
Yep.
No, it's page 8,
Oh,
lines 13 to 17.
thank you.
So, and these are the folks, you may remember the process was that if someone, if the court finds when they're talking about this group of people who it finds are not competent to be restored, they can't be tried for the criminal case because they're not competent to stand trial. Court can do a couple of different things, right? They can release the person into the community if they're not dangerous. If they are dangerous, then they're still held at the facility. And this is that option 3, is they can also at that point release the person if it's because of intellectual disability that they were found not competent to stand trial. Then they can release the person to the Dale custody. Now, kind of parallel to what's the case in existing law. In that situation, you guys set up this process whereby, all right, Dale has to find a placement for the person. And they have a time limit on it. Remember this, the language that you had settled on was in 1 year, Dale has to find the right placement for this person who's been found incompetent to stand trial because of an intellectual disability. What you heard discussed yesterday with Stuart was, well, what if they can't find a placement within that 1 year? And so that's the new sentence. You'll see lines 16 and 17, page 8. So it provides them an extra 6 months if the court finds for good cause that the 1 year period has to be extended. They can give them an extra 6 months.
So
What happens after this?
We haven't been able to find place within a year. We give another 6 months. What happens if we can't find a place within that next 6 months? Can we extend it another 6?
This doesn't expressly allow for that. So my reading of that, if I were the commissioner, would be, I got to find a place within 12 months, 18 months max. And what happens after that is if they would be acting contrary to law. I don't think they would do that, but if it did happen, it'd be a question, I suppose, that the court or somebody would have to resolve. Like if you were the person's attorney, you might say, look, the statute says this amount of time. If they can't find anyone, whatever a creative attorney would come up with in that situation. But one would hope, as is often the case, that with a clear legislative, which this is clear, the clear legislative mandate that the law will be followed.
So the law being followed,
Right.
we're holding them accountable. If we haven't been able to find a facility since Waterbury, does that mean even if we have to send them out of state for a short period of time or whatever? I mean, it's really going to be up to the commissioner and the court judge.
I think so. And I think, yeah, that I think that, if I remember right, the feasibility plan did want to would address, at least for the 2-year interim, possible out-of-state placements.
I didn't want to hear think, I wanted to hear for sure.
I am 100% certain that if you look on page
Is certain the same as
clear,
You're certain it's a possibility?
I'm certain it may be true that, oh yeah, placement and out-of-state residents where clinically appropriate programming can be provided. Lines 19 and 20, page 26. So that's part of the feasibility study. So that's something they could look at in the meantime.
thanks for making me happy.
I do what I can. So yeah, that's the way it's set up. Gives them that extra 6 months. But there isn't any allowance in the language for anything longer than 18 months total. All right. So that, I think is the last change to that section. It is. But then if you turn to the NGRI not guilty by reason of insanity, folks, that section, page 14. Oh, no, sorry. Not there. So, oh, sorry, yeah, page 60.
16.
Yep. And it's just another instance of the language changes, lines 8 and 9, changing it to be clear that these reevaluations can happen either or, either when it happened at both times, either at the 6-month period, or in this case, 3-year/5-year period, and anytime the medical director certifies that it should happen sooner. So you see that new language is on page 16, line 9. And that is the last change between this version, 7.1, and the version that this committee looked at last time. Other than the ones Katie walked you through earlier.
Any questions for Eric? Eric?
You bet.
And why don't we go offline and we'll take a break until the chair is done with,
Testimony at 11.
if we do.
Yeah.
I don't have the agenda in front of me. Thank you.
Yeah.
Good to go.
No, hang on just a minute. Thank you.
It's
It's a,
for 208.
Oh, the amendment.
Yeah, I think he wants to be back for that.
I think he's okay with it. If they're available. I don't know if they're available.
they
Right
are.
now.
in
Yeah.
progress.
I just,
And text them and check.
I have the earlier. I haven't.
yeah, why don't we go out?